Imagine a high-profile crime suspect moved hundreds of kilometers away, not for convenience, but because authorities fear what he can still do. Today we unpack why Vusimuzi cat Matlala was shifted to South Africa's toughest prison and why the courts are now questioning that move. This is Mzansi PoliScope. Stay tuned, this story just got hotter. If you care about justice, high-stakes crime drama, and how South Africa's legal system really works, hit subscribe and turn on notifications right now so you never miss a deep dive like this. Let's get straight to it. This case is not about guilt or innocence. It's about control, risk, and timing. Correctional Services did not casually move Cat Matlala. They removed him from Kgosi Mampuru Correctional Centre in Pretoria and placed him in eBongweni Super Maximum Prison in KwaZulu-Natal, a facility reserved for inmates classified as exceptional security threats. That distinction matters. According to arguments placed before the Johannesburg High Court, officials conducted formal risk and threat assessments and concluded that Matlala's continued stay at Kgosi Mampuru posed operational dangers, not hypothetical fears, specific concerns tied to security management, internal control, and the potential for influence inside the facility. When the state says operational risk, it usually means one thing: the system is struggling to contain the individual, not the other way around. This was not a disciplinary punishment, it was an administrative security decision, signed off after evaluations by Correctional Services and aligned with prosecutorial input. The court was told that high-profile detainees, especially those linked to organized networks, are reviewed continuously, and when the risk profile changes, location changes too. And here's the quiet detail many missed: eBongweni is not chosen for comfort, convenience, or proximity to courts. It is chosen when communication must be restricted, movement tightly controlled, and internal coordination neutralized. If Kgosi Mampuru was becoming noisy, eBongweni was selected because silence is policy there. The transfer wasn't sudden, it was decisive, and once those papers landed before the judge, the message was clear: this move was about containment, not convenience. The real shock didn't come from the transfer itself, it came from how calmly the court accepted it. In the Johannesburg High Court, Judge William Karam made it clear that this was not a power grab by Correctional Services. Officials didn't arrive with opinions or speculation, they arrived with risk profiles, internal assessments, and security reports, and that detail mattered. The judge noted that Correctional Services is constitutionally required to assess inmate risk on an ongoing basis, especially where high-profile or organized crime-linked detainees are involved. In other words, doing nothing would have been the real failure. Here's the bombshell. The court openly acknowledged that Kgosi Mampuru was no longer viewed as manageable in this specific case. That's not something courts say lightly. It implies strain on staff, systems, and internal controls, even if those words never appeared on the record. When a court says we cannot easily interfere, it's not indifference, it's deference backed by evidence. Judge Karam stressed that judicial intervention only applies if a decision is arbitrary, irrational, or procedurally flawed. None of those boxes were ticked here. The transfer, in the court's view, followed process, relied on documented assessments, and addressed identifiable security concerns. In plain terms, the paperwork spoke louder than the protest. And that's the uncomfortable truth. Once the state proves risk with facts, the courtroom stops being a debate hall and starts becoming a checkpoint.
Section 73, in short, says, yes, access to legal representation is a human right, but subject to other legislation, which is in Section 6 of the... So that is what they quote there in their response. They indicate there that a risk assessment was done. I requested informally at a meeting with Correctional Services, can we have the risk assessment? They said it's confidential, so I don't have it, my lord, but what I could see from their correspondence...
Sorry to interrupt you, please, you may be seated. Sorry, I forgot to...
What I could gather from, if you read through that correspondence...
I don't intend to read through all of this, I can tell counsel now.
Yes.
I'm not going, this court is not going to be drawn into an opposed application relating to the issue of accused number 3's incarceration wherever. However, the court did indicate on the last occasion that if there was no joy, especially by the defence, because it is obviously the defence who is affected in consultation and so on. You know what your rights are, Ms. van der Heer. But, and again, the court reiterates that the court sympathises with you and the frustrations and the hurdles you are experiencing in attempting to consult. But having said that, obviously the state or correctional services in particular have got their reasons why they are of the view that your client ought to be kept
My
at
Lord,
that facility.
We 100% in agreement. I'm not going to draw your lordship into that. It is, however, as I think it's been stated in the Supreme Court of Appeal, I have to place these issues on record because
Yes.
that's the manner in which I protect my clients' rights down the line, and for that purpose I do that. So your lordship has got the papers. You don't have to go through it. It just explains to
Yes,
you
no,
the
and
state
I
got an
appreciate
answer,
that, yes.
but we did not get an answer, and we're in the process of dealing with this particular matter. However, my lord,
And it
that-
would appear, though, that there's no imminent joy.
no, there's no imminent joy, but that has
you, basically.
given us a further hurdle. And I need to place this on record because it affects the process that's before you at this point in time, my lord.
Yes.
We were here last week to do a pre-trial. The facts of the matter is the following. My learned friend last week placed on record that we requested certain disclosure. Disclosure was finally given to us on Monday. However,
Well,
Monday...
was that not the additional disclosure?
That was the additional
Because
disclosure.
counsel
Which,
for the state did indicate that disclosure was made last year sometime.
yes, so this is what they call additional disclosure. We respectfully submit based on it. And again, Lord, I'm not going to argue this
Yes.
fully before your lordship. We respectfully submit disclosure that needed to be given to us in any event. It's part and parcel of the case. The applicant's rights at the end of the day
Yes.
to have such disclosure.
eBongweni wasn't chosen by accident, and it certainly wasn't chosen for distance alone. It was chosen because it limits things other prisons can't. This is South Africa's only super maximum facility, designed for inmates assessed as high risk, high impact. Movement is scripted, contact is controlled, interactions are minimal. Surveillance isn't just present, it's constant. The aim isn't punishment, it's containment of influence. And influence is the key word here. When Correctional Services looks at a facility and asks, can this environment still manage the risk? They're not just counting bars and cameras. They're assessing communication, coordination, and the ability of an inmate to operate, directly or indirectly, from inside. Kgosi Mampuru is built to house serious offenders, but it's also a high-traffic, high-density facility. That creates noise, and noise creates opportunity. eBongweni is the opposite. It's quiet by design. Restricted movement, limited human contact, controlled legal and family access under strict protocols. If Kgosi Mampuru allows whispers, eBongweni enforces silence. Reading between the walls, the message is clear. This wasn't about where Matlala was safest. It was about where the system was safest, where decisions could be enforced without strain, and where potential coordination, intimidation, or information flow could be shut down before it starts. In short, eBongweni isn't where you go when the risk is theoretical. It's where you go when the margin for error is zero. The defense wasn't impressed. They told the court, our client is now hundreds of kilometers away from his lawyers. Consultations happen behind thick glass. Preparation for trial is becoming a logistical nightmare. And that's where this case gets uncomfortable, because two rights collide. The state wants security, the accused wants access, And somewhere in the middle, justice is trying not to drop the ball. When lawyers start complaining about distance, you know the file is heavy. Judge William Karam's message was firm, measured, and quietly decisive. He did not debate prison conditions, he did not question security expertise, he did not entertain speculation. Instead, he drew a clear line between judicial oversight and administrative authority. The judge acknowledged that Correctional Services followed the required process, risk evaluations were conducted, security concerns were documented, and the decision to transfer was supported by written records placed before the court. In that context, he made it clear that a court cannot simply substitute its opinion for that of prison authorities. This wasn't approval by emotion, it was approval by procedure. Judge Karam stressed that courts intervene only when a decision is arbitrary, irrational, or procedurally unfair. None of those thresholds were met here. The transfer, in his view, was grounded in legitimate security considerations and aligned with the constitutional duties of correctional services. But there was a second layer to his message, quieter but important. If the defense believes that the transfer materially interferes with legal access or fair trial preparation, the remedy is not argument, it's evidence, a properly framed legal challenge, specific facts, procedural precision. In other words, frustration won't move an inmate, litigation might. Judge Karam wasn't shutting the door, he was pointing to the right one, and in doing so, he reinforced a reality many overlook. When security decisions are well documented, the courtroom becomes a place of restraint, not rescue.
This ruling quietly strengthens the hand of Correctional Services. It tells officials, if you assess risk correctly, document your reasoning, and respect minimum rights, the courts will step back. But it also warns accused persons, being awaiting trial doesn't mean being comfortable. Freedom is lost at arrest, convenience is lost at classification. When the drumbeat of security gets louder, even fairness has to raise its voice. More hearings are coming. Possible applications for relocation. Possible constitutional arguments. This issue isn't settled, it's paused. And like a chessboard mid-game, the most dangerous moves are the quiet ones. The Matlala transfer tells us one thing. South Africa's justice system is increasingly choosing containment before convenience. Whether that choice holds or cracks will depend on what happens next in court. If you value breakdowns that go beyond headlines, subscribe to Mzansi PoliScope. Drop a comment. Was this about security or control? Like, share, and I'll see you in the next one.